Welcome to David and David on Real Estate. Join us as we explore the ins and outs of the real estate market.
Good afternoon and welcome to the David and David on Real Estate podcast. We have a very exciting episode with no special guests today. It's just the David and David like the good old days. And David, I enjoy this because we really get into some great discussions, and today is really no exceptions because we're going to be talking about a class action lawsuit that we're seeing here in the industry. But we are today on episode 91. So thank you everybody for joining us today.
And I always look at that. If it's just the two of us, we always have a special guest. David, you're our special guest. and today in particular with this topic, because I'm going to play, the role of the questioner to some extent, because we're talking about real estate commissions and how that works, and you've got a lot of experience in this area. You're a student of the game to a large extent. I know that you look to see what other brokers are doing, what's going on in the province, what's going on in the country, what's going on in other countries, how different real estate markets operate and things like that. So I think we do have an expert in-house today, and it's David Gorski.
Well, I appreciate that. Before we get into it, David, let's tell everybody a little bit of a background of what we're discussing, what we're talking about. Let's talk about this class action lawsuit, because this is actually pretty big. It's big news in the industry. And it's not only happening in Canada. There's also a very similar class action lawsuit against the National Association of Realtors in the United States. There was a recent undercover episode filmed about realtors boycotting different listings that are offering less compensation to the cooperating side. So there's quite a lot of talk, quite a lot of discussion about this topic. And there's a lot to get into. So David, I'll let you explain what the class lawsuit is about.
Okay, thanks, David. Before I get into that, I've just got to explain something. We're recording this episode, our 91st podcast, June 14, 2023, which is a really important date for me personally. I know we don't always get personal on these things, but today's one of those times where I just want to mention something. So today happens to be my wedding anniversary. So it's number 42, if you could believe that. I got married when I was 3 years old, obviously. And but it's 42nd wedding anniversary. So I want to just wish my wife a very happy anniversary, even though she doesn't watch these podcasts. Maybe this will get her to tune in and watch the first 5 minutes of it. And today, because of that, I'm wearing this shirt. What the world needs more of is Marla Kormans. So that's my wife. My kids made up this shirt for her birthday a couple of years ago. And so one of my favorite shirts. So anyways, I just had to make that point before I get into talking about class action lawsuits.
Well, David, on that point, listen, I wanted to wish both of you guys a very happy anniversary. I think, being together for that long, you guys are a model for everybody to look up to. Every relationship is work. I don't care if it's a work relationship, it's a friendship, but a marriage especially requires so much sacrifice and work, and 42 years is a heck of a long time. So a big congratulations. And I only wish everybody listening the same sort of success with all their relationships.
Well, thank you, David. And I've often said the exact same thing. I just wish that all my friends and acquaintances and business associates and relatives just find the same, lucky success that I've had in my personal life with the love of my life, Marla. And I'm just lucky. You do certain things, you think you're smart, you're making good. This is pure luck. And I got lucky, 42 years of marriage. We were together 5 years before that. So I really always think of it as 47 years together. And how I wasted all those years before I met her. So a lucky day for me.
That's amazing. Thanks for sharing.
Before I start crying, I think I should talk about class action lawsuits. So this is something that they came up in some local papers, local news and everything. And I sent it to you, David, because it was like, wow, where did this sort of, came out of nowhere, like nothing dramatic happened. And all of a sudden there's this headline: a class action lawsuit claims that Toronto real estate brokerages are price fixing commission rates. And like, really? Like commission rate, maybe you'll have to take us back historically, like what goes on in this province and how commission rates are determined. Because generally, what it is here is there's a buyer's agent, there's a seller's agent. Seller wants to sell a property. They're going to sell a property. They're going to determine what price they want to offer it for sale. And they negotiate with the seller what the commission is going to be available, what they're going to earn. And if it's a 5% commission or 6% commission, usually they're offering that they will split that with a buyer's agent. So if it's 5%, each side will get 2.5%. If it's 6%, each side will get 3%, etc. Correct me if I'm wrong, but isn't it sort of that basic and simple, David?
It is, and it has evolved over a long period of time. This isn't something that has happened recently. This is something that's been going on for a number of decades. And you have to remember that prices of real estate were very different 100 years ago, and so were commission rates. Commission rates have actually come down historically over time. Before my time, and these are a lot of my mentors that have bestowed some of this wisdom onto me, but commission rates were 6%. So you paid 3% to the cooperating brokerage, and you paid 3% to the listing brokerage, right? And they were not negotiable. Like, you didn't negotiate your commission. It was 6%. They were not negotiable, right? And then over time, these commissions became more negotiable, and there was more downward pressure on some of these commission rates, especially as house prices have increased in value. 3% of 100,000 is very different than 2.5% of $1 million, right? But there are no set requirements in our industry or in the MLS system that necessitate a certain commission to be paid. It's really the market and supply and demand that dictates what commission rates are. So, we've seen a number of listings that offer 3% or even 3.5% commission to entice realtors to, bring their clients and sell some of these properties in a more expeditious way, right? We've also seen many listings that offer less than 2.5%, that offer 2%, that offer 2.25%, that offer 2.5% minus some sort of a marketing fee. So the market is free to set the co-op commission rate, which is what is at the heart of this class action lawsuit. And this, the dynamics of supply and demand really determine what that commission rate should be.
Okay, so I'm not sure what their cause of action really is on that basis, because it's a negotiated rate. Any seller of a property is going to make a decision. Do I want to retain this agent, and he's telling me he wants, that we should offer it at 5% or 6% or whatever, or I want to go to a discount brokerage, or they're all free to choose what they want and to negotiate that with whoever they want. And they have to figure out, how am I going to get best exposure, where I'm going to get the best service, where I'm going to get the best advice. Like, there's so many factors that go into choosing an agent that have nothing to do with the commission rate. The commission rate is one of the factors, but that's still something that has to be negotiated and discussed and agreed upon, right? So I'm not sure what the issue really is there. And then the other part of this is sort of like, if you're a buyer's agent and you got a buyer that wants to buy a particular property and you're looking at what's available on the market, would you ever steer a buyer away from a listing that's offering only a 2% cooperating commission, as opposed to, well, I'm going to take them next door because they're offering 2.5%? Like, is that something that a realtor would be normally thinking of or should be thinking of?
David, it's a much deeper question. I think the right professional that has the right training and education, approaches their career in the right manner, should absolutely never stoop to that level. And it all comes down from what relationship do you have with the buyer, right? So you have to explain how the MLS system works and how the landscape of buying a house works to the buyer. And when you explain to the buyer that, hey, listen, I'm really representing you in this transaction as a cooperating agent, and the fee for me to do that is 2.5%. That's what I get paid. That's what is my expectation to get paid. Now, I'm going to be showing you houses which are listed on the MLS system, and a number of those houses offer the 2.5%. But there are going to be circumstances where, you know, I'm going to be compensated more or less. Now, in the event that I'm compensated less than the 2.5%, I'm going to come back to you and I'm going to point this out to you. And we're going to take that into account when submitting our offer on the property. But I will absolutely still show you that property. I'm just going to make it evident and point out the fact that, hey, this seller is offering less than 2.5%. So if this is the right house for you, all we're going to have to do is factor in that 0.5% into our purchase price and into our decision making at the time of presenting an offer. That's what realtors should be doing. And these are the type of conversations that realtors need to be having with their clients. And that way, when a seller tries to offer less than the expected earning of the realtor, of the cooperating commission, it becomes a conversation. And a lot of the times it's going to be taken into account by the buyer in their offer negotiation process.
Well, I guess, you know, we should point out for any consumer that might be watching this as opposed to realtor, because the realtor should know it, that it's the seller that's paying the commission in this situation we're talking about for both the seller's agent and the buyer's agent. Okay, even though there's a buyer's representation agreement, it's still that they're going to help, you're going to help the buyer find a property, but they're actually going to be, that buyer's agent's going to be paid from the commission from, it comes out of the seller's cut. It's not like the buyer is going to buy a house for $1 million and have to pay you as the buyer's agent 2.5% of that, right? He's buying it for $1 million. The 2.5% is going to come out of that $1 million. That's going to pay for the buyer's representation, right?
And I want to talk about that for a second, David, because I think that's the bedrock of our real estate system. You know, and I come from Europe. I'm Polish. I was born in Poland. Real estate is sold in a very different manner in Poland. The seller does not pay the cooperating brokerage in Poland. What happens is every realtor that you retain is paid their own salary by their own client. And what happens is, you know, the system works very differently. Buyers typically do not hire their own agent when they buy and sell transactions. So what happens is you have this system where there's very little motivation, right? Buyers are going a lot of times directly to the listing agent, and we know that the listing agent has a relationship with the seller. You know, they had to cultivate a relationship to earn that business, right? So there is no motivation for the listing agent to really work for the best interest of the buyer. And in fact, it's like hiring a lawyer, right? If you get sued, right, by a lawyer, would you go to that lawyer and saying, hey, I know you just served me this lawsuit, but can you represent me and you know, represent me in front of the judge on this matter? It doesn't work like that. You know, there's one lawyer representing one side and one lawyer representing the other side. So the system breaks down. You know, you don't have this smooth offering of services in how they do things. And it all rests on this bedrock that it really doesn't cost the buyer money out of his pocket to be working with a co-op agent, because those services are paid for by the seller. So it actually encourages that person to retain their own representation, and then that person is compensated by making the deal work through the seller. So there's motivation to go in there, to have conversations, and to push the interests of the buyer to make the deal work, right? So the system, it's a very fluid system, and works really well to further the transaction forward.
So in the example that you gave, David, you're signing a buyer's representation agreement with a buyer, and you're agreeing in that, that you would get 2.5% commission. But now you go out and look at properties, and like you said, you might come across a property that's perfect for them, and they're only offering a total 4% commission, which is 2% to the buyer's side. But the opposite could happen too. You might find the perfect property for them, and they're offering 6%, and it's 3%. So it could go either way, right? It could go up or down, and an agent should never be chasing the commission based on the fact, well, I don't want to take them to any 4% properties. I only want to show them 5% or 6% properties because it's going to cost me some money. And I think that's what part of this lawsuit seems to be alleging, that because of this sharing in the commission, there's some agents or brokerage that are discouraging people or their agents from looking at the lower commission properties and only wanting to go to the higher commission properties. Like, is that a real thing? Like, they're alleging that how many they named 11 brokerages. Like, they didn't name specific agents. They named like 11 brokerages in this lawsuit. Like, that's part of their policy. Like, the brokerages are pushing that. Like, have you ever heard anything like that?
Absolutely not. I mean, as a brokerage, we're always promoting the best education, the right way of doing things. We're promoting good practices, right? And a good practice is, again, to explain the buyer representation agreement to the buyer, let them know how the system works. And if there's a situation where there's less compensation offered by a seller, then that becomes a conversation, part of the negotiation process. And a lot of the times the buyer is going to say, wow, that seller is being greedy. I like the house, but I don't know if I want to deal with a greedy seller, right? And that's a determination that the buyer can make when they're informed and given all the right information, right? So a lot of the times the seller will disservice themselves, as when a buyer is informed and has all the information in front of them, when they see that the seller is trying to cut corners and save themselves some money, a lot of the times that will backfire onto the seller in and of itself.
Yeah. And look, you've got way more experience at this than I have, but over the years, I've attended many office meetings at brokerages, your office, other brokerages. I've been part of meetings because sometimes I'm just sitting in the back for part of a meeting while they're doing some regular weekly or monthly meetings. And then I'm there to do a presentation or to answer certain questions about a topic. But I've never heard anybody at any brokerage I've been to ever talk about don't show properties that are only a 4% commission, like only go to the 6%. Like I've never experienced that as part of a conversation. And that's sort of what this lawsuit is alleging, that there's a decision. And not only is it done within the brokerages, but I think it's even alleging the brokerages are colluding together to say, we only want our agents to show properties at the higher commission rates. So nobody, go look at the lower commission offerings. And so that's why there's a disadvantage to those sellers, because they're not getting the traffic. Like, there's collusion amongst these brokerages to do that. I can't even imagine there's collusion within a particular brokerage, never mind amongst different brokerages.
Yeah, no, absolutely, David. And look, I think if there was collusion, right, then the opposite would also be true. I think, if you had listings on MLS that offered, higher commission, then, there should be this crazy amount of interest, and, realtors should be, knocking down the doors and doing whatever they can and pushing their clients, but we know that that's just not the case. I've tried listing, difficult listings like grow ops or listings that back onto a busy intersections or difficult properties. I tried offering more commission. And
like how high? Like what would you, just as an example? Because I never see that.
well, 3% or 3.5%, right?
Yeah.
So it's just slightly more. But on a $300,000 listing, which is the last time I've done this, a 0.5% was $1,500, right? 1% would have been $3,000. Like, we're not talking about a lot of money, but
Right.
if this class action was in fact steering people away, then theoretically the opposite should also be true. And the property expired. It did not sell, offering that higher commission rate, right? So I lowered it to
You'd think,
2.5%.
along those lines, like why wouldn't a seller who might be, having difficulties selling a property for one of those reasons, like why not just offer a 10% commission? Like this says, I'm prepared to, this has to sell. I got a timeline, I got to sell it in. So I'm prepared to make less money. I think I want the price to still be fair market price, but I'm prepared to make less and pay more because I need some traffic. I need agents to come in. So I'm offering a 10% commission, to the agents. You never see stuff like that.
Well, no, because it would be unethical, right? It would be unethical for the realtors to put their interests ahead of their clients. And this is what, agency relationships really are. Agency and fiduciary duties that realtors have to their clients. Realtors need to act in the best interest of their clients, right? And by taking a 10% commission for themselves and putting their interests ahead of their clients, they would be breaking their fiduciary obligations to their clients. So you don't see that very often at all in this.
No, but I'm even talking about like offering, 10% total commission. So, 5%, you'll get 5% if you bring your buyer client here and he buys this property, to give them more incentive to get more people to look at this. You have to be disclosing that, there's warts on this property, obviously, if you're doing it, right?
Well,
so you have to disclose that, but you never
yeah.
see something like that.
I think the average agent, whether they get paid 1% or 5%, right? They have a level of service that they're comfortable providing their clients. And the level of service is the same across the board for each agent, right? Like, so, whether you pay an agent, 1% or 2.5%, they have a way that they market properties. They have a way that they, what service they provide. And they do it the same consistently across the board. Maybe if you pay them less commission, they take certain services out. They won't put you in the newspaper, right? But agents have a very consistent way that they handle all their clients. So whether you pay them 10% or whether you pay them 5%, that agent's reputation is far more important than the bills that they put in their pocket in that particular circumstance. So I think paying 10% commission or paying 5% or paying 6%, as long as the agents are comfortable and they get what they're happy to get consistently each and every single time, I think you're going to get the same consistent service from them. If you paid me 10%, I wouldn't necessarily work any harder than you paid me 5% to list and sell a house. You would get the same consistent service from me, right? So, I think the market over time has figured out what that sweet point is. And by default, by using supply and demand over a large section of data, that's what the market has really determined to be that sweet point between, hey, I can pay the realtor, they're going to make a great living, they're going to have the funds necessary to market my property correctly, they're going to be taking time away in the evenings and weekends from their family, they're going to be compensated. And the market has really, by attrition, figured it out.
So let me give you a different hypothetical just to see how you would handle it. Let's say you've got a seller, fair market price, let's say it's $1 million. I'm going to sell my product for $1 million, give or take, but it's worth around that. And I'm prepared to pay a 6% commission. Okay. And you can split it 50-50, buyer, seller's agent. And then the property goes on the market, and let's say we're not in the GTA that has a pretty good market, even in a bad market. Okay. And let's say the property is really sitting and sitting and sitting. So at some point, would you, as an agent, like you want to get rid of this, you want it to move, you're not getting a lot of traffic, you're not getting enough traffic to entice offers, maybe you've already had price adjustments. At some point, you say, okay, instead of me taking 3%, I'm prepared to take 2%, and I'll offer it out, advertise that there's 4% available to a buyer's agent to try and entice them to get more traffic here? Or is that just like ethically wrong to do? Because now buyers might be trying to bring their clients to this house and sell them on this house because it's in the buyer's agent's interest to try and get a 4% commission instead of a 3% commission.
Well, I don't think it's ethically wrong, David, but I think it doesn't happen very often because it just doesn't work, right? So I think realtors realize that at the end of the day, it's the buyer that's purchasing the house. So lowering the purchase price is far more of an incentive to get the buyers to the table than enticing the realtors to push an overpriced property onto the buyer. So I think the mechanisms are there to try these different tactics. And as an industry, we're free to go ahead and try those tactics. Like if a realtor comes to my office and says, hey, I want to increase the co-op commission, and I think this is going to work because for whatever reason, they're free to do that, right? But I think the data, and we have lots of data, David. I mean, we sold hundreds of millions of transactions, over the last couple of decades, right? The data points that just systematically does not work. That enticing the buyer through lowering the price and getting them to the table is far more effective. And we're talking exponentially far more effective than incentivizing the realtor on the other side.
Well, I think that your answer right there is the right answer to this class action lawsuit. Like, it's just not a practical reason for any agent to, or any broker saying, don't show lower commission properties. Only take your clients to property that's offering a 5 or 6% commission. It's the same logic. It's the same reasoning that you just answered my hypothetical with. It doesn't work. It doesn't make sense. And why would anybody do it? Like, I don't understand the basis of this claim. It just doesn't make sense to me.
Yeah. David, I mean, at the end of the day, as realtors, we have to work in the best interest of our clients in all respects, right? And there's listings currently on our MLS system that are offering $1, right? We still have to go through the motions, and we still have to show those properties to our clients and let them make the decisions. And a lot of times when they have all the information at their fingertips, they themselves are going to say, you know what, I don't want to see this property. The seller's not being reasonable. They're going to be difficult to work with. I just don't want to be bothered, but thank you for bringing it to my attention. And at the end of the day, the sellers themselves are creating obstacles for buyers to come in and not look at their properties, because at the end of the day, they're not making it easy for the buyer, right? The whole reason why this cooperation system works is because it makes it easy for the buyer. The buyer doesn't have to come up with, the 2.5% on top of all the other fees that they're going to pay ahead of the mortgage, right? To hire their own realtor. So our system makes it easy for them to do this, where the money comes from the proceeds of the sale. The seller basically pays for those services, right? And it's simple and it's easy and it works. And when sellers try to contravene this, they get themselves into trouble, right? And that's at the heart of this lawsuit. Now, I think as an industry, there's a pathway to move forward here, and I encourage all realtors to have those conversations, make sure you get that BRA signed, explain to your clients, and ultimately let them make a decision.
Yeah, an informed decision.
An
Like
informed decision.
it should always, there should always be like a real explanation. You take them through the documents as opposed to, oh, if you, yeah, I'm going to help you buy a property, just sign here because I need you to sign this representation. Like you really have to explain it to people. And if they make an informed decision and then they sign it, there shouldn't be an issue. Now, I just want you to maybe just offer an explanation on another point. There are discount brokerages out there. So what's the model that they operate on that's different from the brokerages that are named in this class action? Because none of them would be could be considered discount brokerages. They're all mainstream, top of the market brokerages.
Yeah, so the discount brokerages have, a number of different marketing hooks, I would call them, that they offer, where they have fixed fees, and different listing packages that they offer to the marketplace. And they, some of them do offer the 2.5% compensation if you list a house. So, I know there's a model out there that says, hey, $1,000 listing fee, but we still encourage you to pay the 2.5% on the co-op side. So it would be $1,000 plus 2.5%.
So it's $1,000 to the selling agent.
Yes.
But you're still going to pay 2.5% to a buyer's agent coming in.
Yeah.
Right. So anyway, so as a seller's agent, if you're working for, you're just undercutting yourself and your own fees that you're going to earn. And, big storyline, they're probably not providing any more services than their $1,000 worth.
Well, listen, what I always say to my clients is if a realtor cannot negotiate for themselves, they can't negotiate their own bread for their own family. And if they give away their own money, how quickly are they going to give away yours? Right.
Yeah,
and we're talking about a lot of money here. This is your biggest asset. So do you want a shark at the table, or do you want to have some sort of a pushover that can't even negotiate their own commission?
Right.
You have to think really wisely here. Like you have to make, a smart choice, because the choice that you make will cost you hundreds of thousands of dollars. And we see this every day, David, when I speak to my co-op agents and they say, David, you won't believe the deal I got my clients. And let me explain to you the situation that happened because of the other agent that was on the other side. Right. And then when the same agents are on the listing side, I say, wow, you got 6% over asking. What happened here? Well, let me explain to you, how I did it for my seller clients. There's so much money at stake here, and you really have to hire the absolute best professional, right? But that best professional has to demonstrate their value to you, and it starts the day they negotiate their own commission with you, because if they're quick to not have those tough conversations at the beginning to protect their own commission, you can be 100% rest assured that they're going to give away your own money even quicker.
Yeah, and there's a certain just level of professionalism that has to come with an agent and that representation, and that's why whenever I'm talking with agents, I'm always emphasizing the point that I just made before. Like, you have to understand your paperwork and what you need the clients to sign when you're being retained. But you also have to make sure that you do spend the time to go over it with them. And that everybody should, I've been to your office. I know how you guys, teach and train. Like, there's a way to a presentation, and you have to adhere to that. And you have to go through all the different levels and steps, not just the services that you're going to provide and what your strategy is going to be to sell it, and the timelines and all that part of it, but also what exactly they're buying in your services. What are they getting for your 2.5% or your 3%? What is it that you're going to do for them, and how are you going to do that? And you have to come across really professional, and you have to explain, how you're going to stage the house and how you're going to market that and all those strategies and everything. But, at the end of those presentations, they should be like dying to hire you because you're a professional and you're not going to, just make it all about price and be knocked down. Oh, well, you do. I know you want 2.5%. Will you do it for 2.25%? Like, the answer should be no. My time is valuable. I'm going to earn that money. You're going to be so happy to pay me. You're going to say I was worth 3%, not 2.5% at the end of the day.
David, I got very lucky recently. I got to know the people at the Ontario Real Estate Association, which is responsible for our standard forms. I got to know them very well, and I'm working very closely with them. And what a fabulous set of people. But we are so fortunate as an industry to have these organized boards representing us, because the way the paperwork is designed is that if you follow it and you explain it and you live by all the rules, it's there and it's meant to protect every single party involved. Right. So I think as a professional, you should really learn these forms. Like, you should, I read the APS and all the additions to the forms. I read them, to this day, I know what every single line in them says. And you have to, as a professional, because you will understand how everything works together, right? To not only protect the consumer, which is really important, but also to protect us. Because if we follow the rules, the consumer will be protected. And if the consumer is protected, then we're protected.
Yeah, and that's really important. You've got to cover yourself, which is, as an agent, which is part of it. We go through the same process as lawyers. Like, as soon as the deal goes bad, everything we did as part of that process gets challenged. Okay. And if they can't collect from the other party, who's really the bad guy in the situation, they're going to look to their lawyer. Well, my lawyer didn't explain this, or my lawyer didn't tell me about that, or my lawyer. Well, more often than not, we actually did. But you come across these allegations anyways, which is one reason, like, we're really happy now that we do most of our sign-up meetings through this great process where everything is recorded, because we haven't changed how we go over documents. We're still going over them like we did. Here's a direction retitle. This is what it means. You're going to take title in your name and your wife's name as joint tenants, and here's your birth dates, and please confirm the information is good and the spelling's good. And they go, yeah, okay, move on. So it's now recorded, right? So they can't come back and challenge, because we were involved in a situation years ago on a simple document like that. It was we didn't understand what joint tenants were, or tenants in common. You never explained it to us. Well, I know 100% we explained it to them, because there's no reason that we wouldn't. We do it every single time, but now it's recorded. So you have to.
That one simple thing has such huge repercussions down the line when you're going through a divorce, or when one party is deceased, and
right.
How their share of the property is handled. Like, it has really big repercussions, right? So it's so important that people understand, what happens in those situations. But going back to our conversation at hand, as professionals, it's so important that we understand all the finer workings of these agreements and how they protect everybody. And it's our job to explain all this to the buyer, right? And ultimately, when we explain everything, the buyer is going to make a choice that's right for them, right? If they want to see the property, they're going to see the property. And if they want to move forward with an offer, they're going to have to negotiate and submit that offer based on the fact that they're offering less compensation. And the other thing I want to bring to everybody's attention is that, with amount of information that's available out there, it's getting easier and easier for buyers to make their own determination in terms of property valuations, right? And I have to say this cautiously, but every property that's sold on MLS, or the majority of properties that are sold on MLS, are offering 2.5%. So if you're a seller and you're offering less, that has to be taken into adjustment or into the calculation when we're doing comparable analysis on what that property is worth. And the buyers are doing the same calculations. Right. They're saying, okay, the neighbor next door sold for 600,000 and they were offering 2.5%. Now this guy is trying to sell for 600,000 and he's offering 2%. That's not the same valuation at the end of the day. It's not. It's like saying, okay, that guy sold and he had a brand new deck and you're trying to sell for the same price and you don't have a brand new deck, right? That commission, the co-op commission, adds to the value of the property or takes away from the value of the property when you do a comparable analysis on it.
Right. You really are supposed to be comparing the net value.
Right.
After commission's taken right out of it, what's net to the seller. And that's why I never understand why people want to sell privately. Like I'm always discouraging people from selling privately. They're not really saving the commission in most cases. That's their motive, but most often than not, they're not saving it because it's going to get factored in by everybody looking at that property.
Well, you have to look at the upside versus the downside. Like let's take a look at the opportunity cost of listing privately, right? So in the best case scenario, you saved yourself 5%. The best case scenario, right? But David, how many properties have you seen that have sold, well over value? Like we're talking about hundreds and hundreds and hundreds of thousands of dollars. So you just took, no matter what happens, you took that opportunity away from yourself.
Right. And you're going to spend the time staging your own property without having the advice of someone that knows how to do it way better than you, and decluttering your own property without having the advice of someone that really knows what should be done, and and not getting the proper curb appeal for the home. Like there's so many advantages of using a realtor. Let them earn their commission. At the end of the day, the seller is going to net a higher amount in more cases than not. Plus all the aggravation of booking appointments, showings, open houses. Like to me, it just doesn't make sense. Let the to me, it's the same thing. Yeah, my car broke down. I can try and fix it myself and, grab a manual and go buy some tools that I don't have and then try and figure out how to do it and hope that I don't explode the car. Or I can hire a mechanic and let him do his thing because he's trained to do it. Like to me, it just doesn't make sense.
The one big aspect that people don't talk about when it comes to private for sales is the liability aspect of it. As the seller, you have a personal motivation to sell this property, right? Buyer comes and buys it. Let's say you didn't disclose something or something goes wrong in the transaction. Now that whole liability is on you personally. It's huge. And I would never, ever take that burden as a seller myself. If you have a realtor, they have errors and omissions insurance, they're fully protected, they have deposit insurance protection. There's just, you're using the standard clauses which have evolved over hundreds of years. There's just so many benefits.
Well, another tangent I think we should go on as part of this discussion is double ending a deal. Is that a good idea for an agent? Like pros and cons. Does it make sense for someone to be a buyer's agent and seller's agent on the same property?
Well, David, I heard Tim Hudak speak about this at a conference a little while ago, and he brought up a really interesting point, and he brought in the theory of customer choice, right? And this is a big one, and I'm a big proponent of this. So I think the more government intervention that we have, the less well the system works, right? And I think if people want to be able to approach the listing realtor directly and have them represent them in the transaction, they should understand the limitations of that, but it should be their choice to do so.
Okay, but if you're the agent, okay, and they're saying, I want you to, you've got the listing, and then a buyer comes in and says, and I want you to act for me too.
Right.
Okay. That's what I always worry about. I worry more about the agent's exposure in this than what's going to happen to the buyer or the seller. Okay. Because if
Well,
everything goes well, no
I mean,
problem.
there's no doubt that, like, theoretically, it's very difficult to do it without breaking the rules, right?
Yeah.
And the rules are pretty stringent about this, where, in multiple representation, you no longer have fiduciary responsibilities to both clients, but you still have to act ethically, you still have to act, with integrity, you still have to, you have limited disclosure as well to both parties, right? You can't talk about the motivation about both parties to each other. So it's difficult to do it properly. But I think as the listing realtor, you still have a responsibility to do whatever you can to further the sale of that transaction. And if a buyer comes to you, you have that obligation to further that sale. So I think you have to do it. I just think you need to be extremely careful and very diligent about how you go ahead and work through that transaction. And you need to disclose to both sides that you have limited fiduciary duties. You have, and you have to transact yourself with very carefully with both parties.
Yeah. And some of the issues that arise in those situations are really post the agreement of purchase and sale being negotiated and settled. Okay. It's issues that come up after that, and between that and the closing date, because now maybe there's an inspection, maybe there's something has to be repaired, something has to be fixed, something breaks down, something's missing on closing. And at the end of the day, it's just an easy argument for a buyer and a seller who are frustrated by the process or not getting, what they think is the right answer, the fair deal that they were expecting, is to just turn on the real estate agent and say, oh, you weren't protecting me, you were protecting the buyer, or you weren't protecting the buyer, you were protecting the seller, whichever way it goes. And you're just in a lose-lose situation and not a win-win situation. So I think anybody that's doing it has to be really, really careful. And sometimes it's just not worth it. It's like, no, I'm on the seller side of this. I'd be happy to introduce you to my friend or my colleague who's an agent, and he can represent you as on the buyer's side, and you're better protected in the long run by doing that. You as a buyer are better protected, and me as an agent, I'm better protected because I'm only on one side of this. Something's just not worth chasing that extra commission and exposing yourself to the potential liability.
I completely agree, David. And in those cases, we do recommend that they refer out to a different realtor. I will say that at our brokerage, we have a large brokerage. I will say we don't see a lot of multiple representation issues in litigation or in the complaint process. And I think it's because as realtors, we really know our clients well. So when we see, the personality types where we see some of these red flags, then you're right, we refer them out and we stay away from them as professionals, because we know that they will turn into litigious matters. But I think the fact that we are seeing such low issues in this cases tells me that there is a trusted relationship. And at the end of the day, both sides are represented by different legal counsel that can also step in and help, sort some of these issues after the agreement goes firm.
Yeah, and that's what you clearly have to do if there's a conflict issue that comes up. Okay, you'd have to say, hey, look, I can't really help to resolve this any more than, up to a certain point, but buyer has a lawyer, seller has a lawyer. Let's make sure they get the information and understand the issue, and then they can negotiate on behalf of the respective parties, because there's separate representation at that level. And the agent sort of has to back out of it. Okay. But sometimes an agent is left, even if when that happens, and unfortunately, because the market is difficult, we're having more trouble closing transactions, even though a lot of times green for sale sign, everybody's happy, that all negotiated out well. But now some of his buyers are just running into problem. They can't close. They can't get the financing, those type of conditions. It's just a function of the market. So as soon as a transaction doesn't close, like the seller would say, well, why did you bring me that buyer that didn't you qualify that buyer? And I lost the opportunity to get other buyers, and you double-ended both these, you brought this buyer to me, you double-ended it. It just throws the agent back into the equation, right? And when we're in a situation, a market like we're in right now, where transactions are just more difficult to close, unexpected, unforeseen circumstances are affecting a lot of buyers and affecting their ability to close or to close on time. And you just got to be extra careful as an agent right now about getting involved in any double ending, I think, because when it goes bad, there's finger pointing, and you're at the front of the line if you're double ending. And it's no different for us as lawyers. Like if we're acting for both a buyer and a seller, as soon as the deal goes bad, it doesn't matter who was right, the buyer or the seller. Everybody's going to say, well, you were the lawyer acting for both. How come you have a conflict, right? It's just not a good thing.
Well, I think that's a really strong message. And I think, that is absolutely sage advice, given the market that we're entering and given higher, costs, higher carrying costs and more tightening from the banks. I think, you are right, David. I mean, you are at the forefront of closing transactions. So if you're seeing more difficult transactions and difficulty in closings, then you're right. When the deal does go sideways in a big way, not in a small way, then there's always finger pointing. And if a realtor double-ended that deal, that's an easy finger to point at always.
Yep. So anyways, it's a function of the current market that sort of brings these type of issues to light a little more so. Like we wouldn't be having the same conversation, a couple of years ago in that type of market, because things were closing on time. People weren't trying to get out of deals, weren't trying to walk away and things like that. It's different. So I'm just saying, be careful. If you're an agent out there, be careful. If you're a lawyer out there, like just not a good idea. There's other, a lot of times you're just better off being on one side of a transaction. But anyways, that sort of was a bit of a sidebar to the major issue. So I'm convinced everything from I've heard from you so far, David, like I don't think this lawsuit's going anywhere. Like I just can't imagine that they're going to be able to prove that there's something nefarious going on here, and to the detriment of every seller out there that dared to sell and offer a commission that was less than 5%. Like they should all be joining and be part of a class action suit because they all got less than their fair market price because agents weren't bringing buyers to their place because they wanted to get an extra quarter of a point or a half a point. Like, I don't know.
I agree, but in the States, David, a very similar class action lawsuit was filed I think about a year ago. And I've just learned that a federal judge certified the class action lawsuit. So I'm not sure what that means, but
that just means it's going ahead, that he found there's enough, the argument that there's enough merit or potential merit in it that they're going to allow it to go ahead and then let someone prove it. But don't forget, the US system is a little different. Like they may have hired lawyers on a purely contingency basis that'll fund the lawsuit themselves. Like the law firms fund those class action lawsuits and look to make a bunch of noise and get everybody to, all these brokerages have to defend it. They've got to get their insurers involved to defend them. And at the end of the day, there might be a settlement because the insurance companies might decide to settle it and offer something. And the lawyers will get their money out of it and the clients might get a little bit from it. So it's a different system. So I don't pay as much attention to the, the US, they'll sue anybody for anything.
Right. So you're saying our legal system makes a little bit more sense in there. So that's,
Yeah, we have a little bit of contingency fees too, but we don't have those type of class actions that are just, without a lot of merit to it. But look, a judge has to make a ruling on this one too and decide if there's enough evidence to, prima facie evidence to at least let it go forward and let someone try and prove a case. Or they might say, like, there's nothing here and we're not letting this go ahead.
waste the court system's time.
A waste of time.
Okay. Well, David, great conversation as always. I love having these legal conversations with you. I think it's important for realtors to kind of understand. And I think what it does is it kind of gives context to kind of everything that we talk about, everything that we preach, because if you follow the rules and you do things correctly, you will be saved by doing that, right? So it's always good practice to make sure you follow the rules, you understand these forms, you explain these forms, you arm your clients with knowledge and let them make the best decision for them.
Yeah, and be a professional and demand by your professionalism that you get paid properly for the services and your expertise that you're providing.
And you have that right. As a professional, you have that right. You deserve to be compensated. That is not price fixing.
Right.
That is just you being a professional and you demanding to be right. But if you make a decision not to show a house, or if you steer your clients, or if you do things that puts your own self-interest in front of your clients, then you are steering and you're breaking the law.
Right.
There needs to be repercussions for that sort of behavior, because, as somebody who loves this behavior, as somebody that loves this industry, I don't tolerate things like that. And I don't think anybody who loves this industry would ever tolerate behavior like that. And we're strictly against it. So, arm yourself with knowledge and you do great.
Yeah. Knowledge is king. Informed knowledge.
Absolutely.
Thanks, David. You were a great guest on this podcast today.
Well,
you're double ending this podcast. You're both host and expert guest at the same time. So that's a good double end for you.
Well, as long as I had you to keep me away from trouble. So thanks, everybody. Have a great week.
Thanks, everybody.